statutory rape in Georgia. Ryan Brown from J. Ryan Brown Law. We're talking about a crime that we unfortunately see pretty often here in Georgia, and that is statutory rape. The difference primarily between statutory rape and rape is the element of force, right? A statutory rape is when two people may agree to do something, but the one of them agree to a sexual act or sex, and one of them is not old enough to lawfully consent, even though it wasn't done forcefully, and maybe in reality they both agreed to do something, but the person is just not of age to consent. The age of consent in Georgia is 16, so someone under 16, a 14, 15-year-old or younger, cannot legally give consent to a sexual act. So unless they are married, and if they're married, then they can't be the victim of a statutory rape just by virtue of their age if they are married to the defendant. The punishment differs based on a few things. Statutory rape is generally a felony. It generally carries a lifetime on the sex offender registry, but the range can vary. If someone is under the age of 21, the range of punishment is generally 1 to 20 years. If they are 21 or older, the range of punishment is generally 10 to 20 years. And then there is a portion of the law that provides for essentially teenagers to not be guilty of felonies. So if the victim is 14 or 15 and the defendant is 18 or younger, but not 4 years older than the victim. So we're talking about maybe there's a 15-year-old and a 17-year-old. Whereas back in the day, that 17-year-old would have been guilty of felony statutory rape. Now, they could still be found guilty of statutory rape, but it would be a misdemeanor and not require a lifetime on the sex offender registry and not carry decades in prison.